An offshore company is a legal body registered in one of the offshore jurisdictions. The most widespread model of such company is a limited liability company. Lately, LLC and LLP companies have received a huge popularity. Offshore companies pay a very small income tax or don't pay any tax at all. Other local taxes such as VAT, sales tax, capital duty, or profit repatriation tax don't spread on them either. In the majority of offshore jurisdictions, it isn't required to conduct the accounting tax or to hand over the financial statements. Usually it's forbidden for the offshore companies to have a commercial activity on the territory of the country of registration. As often as not, it's also forbidden for them to own real estate in the country of registration. Corporate laws of the majority of countries of our modern world are based either on the common law or on the civil law or on the mixed type law. Accordingly, the organizational legal forms of foreign enterprises are based on the application of one of these three types of law. In the majority of countries, the company is established by means of execution of the foundational documents, such as a memorandum and articles of incorporation. A memorandum contains fundamental rules that must be respected by any offshore company. The memorandum is formed in black and white and is endorsed by signatures. The benchmark of the subscribers under the statute differs depending on the demands of the jurisdiction of the establishment of the enterprise. The signatures of the founders must be recorded by a notary or by a trusted subject, having the suitable license. There, where it's required by legislation, each subscriber signs under the number of shares he subscribes for. In some countries, the subscribers can be not only individuals but also legal bodies. Usually, the citizenship and the point of residence of the subscribers and shareholders don't matter, but according to the tradition and essentially to facilitate the registration, formal subscribers, professional agents, are used. They put their signature under the memorandum and other founding documents and pass the company to the client after its establishment. The article that determines the kinds of business transactions of the company contains as a rule either a very long enumeration of all the potentially permitted activity types or a short list of the activities forbidden for the company, determining this way that all the others are permitted. If a company practices something that is beyond the scope of the activities permitted by the statute, in this case, such an activity is ultra vires and has no force. Herein, neither the company nor its members have any rights to assume measures with a view to represent such an activity as the one that is effective. The Articles of Incorporation contain internal rules of the administration of the company, including rules of issue and delivery of shares, requirements and measures applied in case of non-payment on shares, increase and decrease of nominal capital, order of meetings of shareholders and directors, appointment and dismissal of the directors, requirements to the directors, secretaries, authorized delegates, their rights and obligations, the order of accounting, regulations for the dissolution and liquidation, regulations for the stamp. Formally, the Articles of Incorporation is a contract between the company and its present and future shareholders, and is obligatory for all the shareholders, directors, and other employees of the company.